I'm joined by Scott Blair for the third in our interview series. Scott's an advocate at Terra Firma Chambers. He's been involved in numerous landmark licensing cases, and he's also an expert in administrative law. Scott, welcome to our interview series. Thank you so much for taking the time to join me today. And how is life for you in the current situation?
Well, first of all, thanks very much for asking me to become maybe not a YouTube star, but part of the firmament that YouTube is these days. And it's nice to know that somewhere my face and voice will be recorded for posterity after I'm long gone. Happily, I have managed to get through the pandemic thus far. Family are the same. I hope the bulk, if not everyone out there listening to this, has managed to get by, whether health terms or economically. A bit scary at the beginning, as with many independent legal practitioners, wondering what is going on when we got that message from the Prime Minister back in March, followed by the First Minister. Really, really dystopian experience. And here I am in December, still here, still practicing, and still happily keeping good health. As you know, Jack, I live out in the sticks, so to some extent living in the countryside has been okay, been better than it normally is, simply because of a bit of a buffer between the pressures of the pandemic that people face in the city and working and living in a more restricted environment. That being said, it has had a sort of bunker-like quality, and you and I have exchanged various emails about my hillbilly existence in the hills during the last few months and stockpiling food, and that's before Brexit. All in all, coping and delighted to be asked to be involved in this fantastic project, Jack.
Well, that all sounds good. You've got a spar and you've got an Indian restaurant and you've got a quality grocer, Scott. I mean, you don't need any more, do you?
Well, you don't. You know Lochwinnock, where I stay. You're a visitor to our farm shop. All boxes are ticked living here, for me at least, and for my wife Wendy and our dog Barney. So we're coping.
That's good. You know that one of the things that's bugged me, and I suspect bugged lots of people, is this constant conflation between guidance, the law, and guidance. We get guidelines represented as the law, we get law represented as guidance, and somewhere in this mix is this absolutely bizarre approach to the question of guidance. We started off with the Scottish Government issuing guidance that had absolutely no statutory basis at all. No one really knew what it was doing there. Then we had statutory guidance, but it was never an offence to not follow the statutory guidance. And then we had and have the health protection, coronavirus restrictions, directions by local authorities, Scotland regulations, to which local authorities must have regard linked to an ability to give directions. You wrote an article for this, the SLRP Commission, that's available at slrp.co.uk for a free download. And it's called Guidance. It's called Guidance in the Guidance. It's an extraordinary mess, isn't it? What do you make of that?
It is a mess. I don't think, in fairness to the Scottish Government, it can all be laid at the door of Scottish Government. I think, to a degree, it's the loose use of language in the media. And I can understand that at one level, where most people go through their lives without thinking about the law. Most citizens in Scotland never really think about the law in day-to-day affairs. As lawyers, of course, we know we're surrounded by law in everything we do. Every time we buy something, it's a contract. Every time we jump in our car, there are potential risks. When we get into trouble with the authorities in the criminal law, well, that's the law full and sharp. I think this is the first time the public have had to think about the law day on day. And I think the media plainly have a role to play there. And the media have been very loose and fast in reporting what is guidance, what are guidelines, what is the law, what is the current law. So I think part of the problem is the way in which the message has been relayed through mainstream media, but also perhaps social media. That being said, I'm not entirely sure the Scottish Government can be exempt from any criticism. While taking into account the enormity of the task that they've had to undertake, and the unprecedented level of this emergency, certainly in peacetime. Nevertheless, it would be helpful, or would have been helpful in my view, if the government had perhaps issued, dare I say, more guidance on what the distinction is between law and guidance. A standard response from Scottish Government, even before the pandemic, is to say, well, speak to your lawyer. These are matters for the courts to interpret. I have to say, I don't think that's good enough, where just about everyone in this country has to have some grasp of the distinction between what is law and what is guidance. And part of the reason I did that wee article for you, Jack, of course, was to try, in my own way, explain that guidance is not law, that a failure to follow guidance is not in itself a breach of the law, that you can choose to depart from guidance provided you have a rational basis for so doing, and you can provide adequate evidence to show that you have come up with a reasoned view as opposed to a gut reaction on why you've not followed guidance. An example I gave was the old chestnut of playing music in a restaurant. I think we can all understand the difference between thumping music in a rock music type venue, if that's still the term with kids, and a more romantic, relaxed venue in a high-end restaurant where music in the background might be conducive to a romantic night out, or even just a good meal. The point I wanted to make in that regard was to say you could choose to depart from the guidance on no music, provided there was a rational basis for so doing, and you could demonstrate that you weren't undermining the objectives, the public health objectives behind the coronavirus restrictions. Now, I managed to do that in an article that ran to a couple of pages, and in fact, I summarised the legal tests as to how one approaches guidance in a couple of paragraphs at the end of that article. And I personally would have found it helpful if the government had put out there in some shape or form, in summary, here is a distinction between guidance and strict law, for the public to understand, and in particular for the licensed trade to understand. It's fine for operators who have access to specialist legal advice and who can pay for that advice to come to someone like myself or yourself, Jack, for guidance on the guidance. Not everyone can do that in the licensed trade. Many businesses are very small. They're struggling as it is with paying the bills day on day, keeping their businesses afloat, paying the staff, paying the suppliers, paying the mortgage for many people on their own home, without the need to take counsel's opinion. So I do think there has been a failure there on the part of the government to get the message out there that guidance and law are different, and to at least provide some kind of summary that the average person could pick up and understand as to what the differences might be.
Well, of course, mainstream media haven't helped, because I remember, I think it was in Sky News, a presenter was saying you could be fined for breaching the guidelines.
Yeah.
Well, no, you can't.
Yeah.
And sometimes, I think, dare I say, in a deliberate way, what isn't the law is represented as the law because it's a convenient thing to do. The travel restrictions, for example, that are now law, maybe come back to these a little later, were at one time, I thought, represented by the First Minister as something you mustn't, in the full sense of the word, mustn't do. What really has surprised me, and we're departing the licensing part just very briefly in the lead up to looking at some licensing cases about the restrictions, is that the public at large seem to have been taking these unprecedented restrictions on the liberty with a relative surprising equanimity, or perhaps are just not bothering about complying with some of the more severe restrictions. I mean, is it not a remarkable thing? We started off at the very beginning with the first iteration of the restrictions that you couldn't leave the place you were living. That was the headline, couldn't leave. Unless you had a reasonable excuse. And there was a list of reasonable excuses, but that wasn't exhaustive. As we stand at the moment, in Tier 3, there's no one in Tier 4 at the moment, but in Tier 3, or rather Level 3, you can't leave your local authority area. In other words, it's an offence to cross the boundary. And also, it's an offence to leave Scotland. It's also an offence to enter Scotland. These strike me as quite remarkable restrictions, and to which there have been no challenges. So far as the trade is concerned, there have been two court challenges, one in England and very recently one in Scotland. I'd like to look at these, Scott. The first one we'll look at is the case of Dolan, which is an English judicial review in connection with the first version of the English restrictions, this being obviously from a hospitality viewpoint. So can you tell us about Dolan before we move on to KLR, the KLR case in the Court of Session?
Yeah, absolutely. Dolan's a really interesting case because it runs to, I think, roughly 100 paragraphs of closely reasoned analysis from the Court of Appeal. Effectively, what Dolan was a challenge to the first iteration of the English regulations, where the applicants for judicial review tried to argue a number of things. They argued in the manner of unpeeling the layers from an onion that, first of all, the restrictions were simply not allowed by way of the statutory instrument that introduced them. And they argued that the primary legislation, the Westminster Statute, didn't give the government the power as the executive to pass these restrictions. The second argument broadly was that the restrictions, even if they were within the ambit of the primary legislation, were nevertheless unreasonable. And there were a number of strands to this. It was argued, for example, there was a lack of evidence to support the width of the restrictions imposed. It was argued also that Parliament had not been given a sufficient opportunity to scrutinise the restrictions in question, and therefore that undermined the role of the Westminster Parliament. I suppose for present purposes, the Scottish Parliament could be thought of in the same way in a Scottish context, undermined the role of the legislature, and that violated a basic constitutional norm that legislation which is restrictive, hugely restrictive of the rights of the citizen, ought to be something which is scrutinised at the Westminster level rather than at committee level. On the back of these arguments, we also found a whole slew of arguments based on the European Convention on Human Rights. Now, Dolan threw everything into the mix. Dolan argued that the restrictions violated rights to associate with one's family, one's friends. They restricted one's liberty by requiring you to remain at home, in effect in a form of house arrest. Indeed, one of the cases cited by Dolan is a case about the house arrest of a mafioso in Italy to support that argument. Dolan also argued that the restrictions impacted on the right to exercise religious freedom because, of course, it limited difficulties in attending a religious mass or ceremony. For licensing lawyers, Dolan was quite important, although not strictly a licensing case. It nevertheless did touch on Article 1 of the first protocol, which of course is the right to peaceful enjoyment of possessions. And we know already from Scottish cases such as Cat Scratch that licensed premises, licenses are possessions for the purposes of the protocol. And what Dolan sought to argue was, well, these restrictions, which have been brought in at short notice, represent an unjustified interference with essentially the right to make a living and the right to derive an income from business. Dolan in particular operated a small airline, and part of his argument was that the restrictions on aircraft coming into the UK effectively brought his business to an end. Well, it's fair to say that the Lords Justices who dealt with the matter were not impressed by any of this. It's a fairly robust judgment. They took the view that the order was well within the ambit of the primary legislation. As for the reasonableness argument, we see there, I think, the first articulation of the difficulty we come on to see in the Edinburgh case that we'll discuss shortly, whereby what the court seems to be saying is where one is dealing with a very complicated issue and a fast-moving one where the scientific and medical advice is changing day on day, the court should be very reluctant to strike down as unreasonable measures taken by the executive in seeking to prevent and contain the spread of this dreadful illness. So there's a real message, I think, in Dolan from the point of view of public law that this is hands-off territory. Unless there's a clear illegality in what is being done, then it's going to be very difficult, in my view, to persuade a court that any measure passed by either Westminster or Holyrood in terms of delegated legislation is going to be viewed as unreasonable. And one of the reasons that the court came to that view was they did not accept the argument put forward in Dolan that the Westminster Parliament had little say in the regs. They were able to, for example, identify that it was quite clear that there had been specific consideration of the regulations by Westminster, and accordingly the argument that this was something that's simply been rubber stamped by Westminster on the fiat of the Westminster government was simply wrong. In other words, a key feature of Dolan was that it could be shown that there had been sufficient consideration through the affirmative resolution procedure on statutory instruments by Parliament. As for ECHR, I didn't find any great surprise in the findings of the court on ECHR. To show that your liberty has been restricted is a very high test. You need to show that you're continuously supervised and controlled, and also you are not free to leave where you stay. Now, even at the most stringent form of the regulations, at no point has either Westminster or Holyrood passed regulations which say you're absolutely barred from leaving your own home, or you're absolutely controlled and supervised in everything you do by the state. As for Article 8, the right to see your family, the right to see your friends, the right to get out there and live your life, it's a qualified right, and it can be limited if necessary for the legitimate aim of the protection of public health. So no surprises there when Dolan lost on that argument. On the property rights side of things, I think again with resonance for the Scottish context, the court said a number of things. One was that, broadly speaking, any impact on business couldn't necessarily be related to the restrictions themselves. For example, it was pointed out that many people chose not to travel because of concerns over public health. And that wasn't a direct consequence of anything the government had done. So if you were in the airline business, for example, if your customers choose not to fly, that's not really the fault of the government. That's just a fact that arises from the pandemic. On the proportionality point, one of the factors fastened onto by the court was essentially that the Westminster government had put in place a raft of economic measures to try and support business through this difficult time. And of course, we've seen over the last few months things like the suspension of requirement to pay VAT each quarter. We, of course, all know this concept of furlough. It's now part of daily parlance. There have been various packages aimed at business rates relief, so on and so forth. So again, looking at matters in the round, while the court, I don't think, was expressing the view that there was no control on business, because plainly there has been direct control in business, particularly in the licensed trade. Some businesses simply cannot open, such as the adult entertainment sector, or other businesses have been subject to huge restrictions, such as the wet-on trade. Nevertheless, one of the factors that the court, I think, is likely to take into account in a Scottish context is the fact that some attempts have been made by Scottish government, like the Westminster government, to mitigate the economic impact of these restrictions. And while it remains to be seen what a Scottish court will decide, I can well see that being the argument that Scottish ministers will run if a similar challenge is mounted by the licensed trade in Scotland on possessions grounds, peaceful enjoyment of possessions grounds. So in short, Dolan is not good news for those seeking to bring challenges to this type of restriction. and I think it will set a template for cases going forward. Famous last words, who knows, other lawyers may take a different view, and there may be different challenges out there that have yet to be focused on. For example, just in passing, I recall in England, there was also an attempt at judicial review brought by the company Gay Lounge. Now, I'm not sure where that challenge has got to. I suspect it's now historic. But that was brought in at a time when the curfew was introduced, the infamous 10 o'clock curfew. And of course, we can all remember watching the TV that night and seeing all the kids in London spilling out of the nightclubs and onto the streets and partying outside. And one of the arguments in Gay Lounge was, well, it was irrational to introduce a curfew when in effect it created a greater problem than with a staggering of closing times. Now, I have to say I found that argument quite attractive as an argument, and I know other licensing lawyers did as well. So I'm not saying there's no scope for a challenge given Dolan. What I am saying is that it has to be, I think, fairly specific and directed at matters of some cogency, rather than these big picture arguments of the system as a whole is unfair or it strikes the wrong balance. Courts are going to be very reluctant to get into that kind of argument.
I think so far as the curfew is concerned, restricting the terminal hour for the operation of licensed premises, or indeed closing them, the argument, just to build on something you said a second ago, the argument is that what that does is it encourages house parties. The enforcement of the law about that, unless there's something spectacular happening with 50, 60 people in some rented venue, unless except in that kind of situation, these are virtually undetectable. And of course, some people would say also that fuels people drinking at home, and that more, and that might not have a very good public health look. The Scottish Licensing Trade Association sent a pre-action letter to the Scottish Government expressing its concerns about the lack of evidence upon which the restrictions have been based. It got a reply which was not considered to be very satisfactory. And Audrey Junior talked to Colin Wilkinson, the SLTA managing director, about this in the second in the interview series. So not quite sure where that is at the moment, but certainly one to watch. So far as Scotland's concerned, of course, we had, I think it was decided on the 11th of December, the case involving KLR and RCR International Limited, which basically was a challenge to Edinburgh not being taken out of level 3 in the order of restrictions. I have to say, I mean, there is a possibility, we're going to learn in a second, as many viewers may know, that case failed. There is a possibility, I suppose, of a reclaiming motion, Scott, isn't there? Yeah. Yeah,
that's a possibility still at this stage. The case was brought as a judicial review of the decision of the First Minister not to take Edinburgh out of level 3. And Dolan was mentioned in that case and indeed relied on by the Scottish ministers. It was an attempt to suspend that decision of the First Minister and to suspend it ad interim, as lawyers say in the Latin. So in terms of the procedure, it's still at quite an early stage. It is not by any stretch the final decision in the case, but it's also fair to say that Lord Ericht, who dealt with the case and whose opinion can be read on Scott courts, I think I'll credit to him for producing that an opinion of that length in the time available since the case was argued. And I gather that the case was argued into the evening. I think that gives one some indication of the length of argument, the case having started in the morning. To have produced something of that length. But essentially what was argued there was broadly the lack of evidence to support the view that Edinburgh should remain in level 3. It was argued that the government had failed to follow its own criteria and had failed to act contrary to public health advice on the ongoing picture in Edinburgh. There were also ECHR arguments in the case, proportionality featured. So very much a Scottish version of Dolan, but focused more, not so much on the regulations, but rather a decision made by the minister under the regulations as to whether one local authority should be moved out of one tier and into a lower tier. So what you're dealing with there straight away is an exercise in discretion. And of course, when you're dealing with an exercise of discretion, the old test is Wednesbury. Was a decision of the First Minister so unreasonable that no reasonable First Minister could have reached it? Now, although it was asserted by the petitioners that there was a lack of evidence to support the First Minister's findings, Lord Eric was quite robust. He said he could find nothing to show that that assertion was correct. And I think it's also important in that regard to understand what evidence means in this context. We are not in the territory of black and white evidence. We are not in the territory of right and wrong. Opinions can differ. And what he was quite careful to do, and what the argument for the ministers was essentially that one was in a territory of opinion and advice. That advice and opinion had to be tendered on a, as it were, precautionary basis. And it was open to the First Minister to give whatever weight she thought appropriate to the varying points of view expressed in the various opinions and advice received. And it was wrong to argue that the government have in place criteria or tests which they had failed to follow. At highest, there were indicators in place which may or may not trigger the First Minister exercising her discretion not to put the authority into a lower tier, or of course in the opposite direction if the case warranted it. So the court very much stressed the width of considerations in play here and disavowed any view that there was a lack of any proper evidential basis for the decision that was reached. While one might take a different view of the evidence, as the petitioners plainly did, it wasn't a case of there being no evidence, simply that the evidence that was in place was not perhaps what the petitioners would want it to say. On the ECHR arguments, again, we see pretty much the adoption of what was said in Dolan, fairly short rejection of those arguments from Lord Eric. And it's also important to note that along the way, he specifically addressed the point that the question of restriction and the level of restriction was something that had been expressly addressed at Holyrood level and not just by the First Minister. So when we get back to that argument about constitutional fundamentals and approval by the legislature, the court was also able to identify that this was very much not just the First Minister's view, but was a view that had also been considered at the level of Holyrood. I think one also has to be aware that one of the difficulties in running a challenge of this kind, as I think the court in Dolan makes clear, is that the daily picture is changing day on day. At the beginning of December, we were hearing the great news that there seems to be a vaccine or vaccines out there. Thank goodness for that. But equally, we're now hearing about rising levels of COVID. We're now being told that London will remain at the highest level. We are being told that there are discussions, certainly at the Westminster level, of should the proposed relaxation in restrictions for the festive period in fact be implemented. And of course, we have the First Minister in Scotland saying, well, okay, it looks as if we're going to relax the restrictions for the festive period, but to coin a phrase from a Scottish sitcom, Gonnie no day that. While you can do it, perhaps Gonnie no. So I think one of the problems the court faces in any of these challenges is that the evidential basis for any decision is built on sands that are perpetually moving and shifting and changing. And it's very difficult, I think, for a court to fix on a particular day or target in terms of the evidence it has to consider when one is dealing with such a fast-moving picture.
Yeah, it'd be interesting to see how it plays out, but it does not, on the basis of what you've said, look at all promising. Just before we move on, there is an interesting set of reactions to the case that you've just discussed on the Hey Legal website, where a number of commentators give their take on the decision. That's certainly worth a look. And also, it comes back to mind, not in a licensing context, but looking at the coronavirus restrictions generally. In the Hey Legal YouTube channel, there's a three-way discussion between various lawyers discussing the extent of the restrictions, their appropriateness, and so on. So that's certainly worth a look at as well.